Good morning, good morning, good morning. I'm so glad everybody is here. I didn't even get to finish my coffee. I didn't even get to get dressed. I'm still in my pajamas. Good morning, everybody. But I saw this and I said, oh, I got to go live. I promise. So we're in the courtroom right now and nothing has happened yet. Okay. It's all just, preliminary, they're just waiting. Nothing's happened. We're not missing anything. Um, See, there's no sound, no nothing. We're not missing anything. I just wanted the notification to go out and everything. I think, Remy, I think this would actually be her ninth attorney. I think that Cashman was number 8, and this one would be number 9, not 10. So she had her pro bono at first, Padilla, Bankowitz. I know there were some in between, but these are okay. The first attorney that was appointed by the court, then Padilla, Bankowitz, Hobson, Cashman is 5. And then there were 3 that were that filed the motion to dismiss based on conflict because they had either represented George or somebody else and they couldn't do it. So that makes 8. This would make 9. Yes, 9. That's where we're at. Okay. I'm not exactly sure what is going on with the live stream right now, but we will just sit. We will be patient. And yeah. But good morning. No, I wish I could say that I was the only one doing this live, but I think that there's a couple of other people probably will catch it live too. And hopefully the people that normally watch with me will come over here. I see that you guys are here. Good morning. Good morning. Let me say hi to you guys while we wait. Good morning, Katie. Good morning, Samantha. Good morning, Shelly Beans. Good morning, Music City Mom. Good morning, Sexy Wild Thing McLevin, freaking Babyface Claus. Good morning, Kim Anderson. Good morning, Danielle. Good morning, Roberta. Good morning, Karen. Good morning, Preschool Granny. Good morning, Remy. Good morning, Wee Gobshite. Good morning, Emily. Mandy, good morning. Teacup Kraken, good morning. Good morning, Dee. Good morning, good morning, good morning. I think we've got everybody. Good morning, Neat Noodle. I think everybody's here. There we go. It seems like some things are happening. I guess we're not clear to turn the good morning, Sherry. We're not clear to turn the sound on, but never fear, your girl is here. Love, Louie. Oh, thank you. I saw another channel streaming it, but then I got the notification for you and quickly switched over, and I appreciate that very, very much. If you guys have people that you know are interested in this case, and they want to watch this live over here with some cool people, share out the stream. No pressure. Give the stream a thumbs up if you don't mind. No pressure. Give it a thumbs down if you feel like it, if you just want to see what happens when you do it. It's cool. Oh. Let's see what's going on. I need to know what's happening with those blinds in the background there. They look like some of them are doing their own thing. And I'm not sure about that. I don't see Sarah yet. That doesn't mean anything. Oh, wow. Thank you, Wee Gobshite. I started on 2 other channels, but then Jen popped up, so I'm here for sure. Thank you. Thank you. Like this, we've been waiting for this. Hey, Kathy Ford. Good morning, babe. Mr. Shine, good morning. Okay, so no notifications today, just you. Well, let me say this. I scheduled this live at, I think, 8:43 or something like that. So YouTube is sometimes stingy with the notifications. Like, I think they give you 2 in 24 hours, something like that, priority notification. Um, that's the rumor. I don't know how true that is. I can't really figure out YouTube, some of their stuff that they do. But anyway, so it was kind of last minute notice. They really prefer that you give like a couple of hours notice. But when I was scrolling this morning, checking to see if there would be a live stream, Law and Crime, their notice went up late as well. So I don't know what the deal is with there, but that's the deal. So, as soon as I saw it, I was like, oh my gosh, I can't believe this. I got to go live. Because what I was doing is first I check the tubes, right? That's my usual routine. And then I will check Google for news. And I thought for sure this was going to be one of those that was uploaded later, but it's not. And so, and I'm glad that Law and Crime is carrying it on their stream, because when the local news, I don't know what the deal is with the local news feed, but their audio sometimes is not good. And so, hey, Mayla's mom, good to see you. So yeah. All right. And so, okay, let's talk a little bit about what's going to happen today. And I want to say right at the start, I woke up at like 7:55 this morning. We went late last night, and it takes me a little bit to wind down. So I fell asleep late, obviously, and I got up late, obviously. My morning routine consists of first taking a 5-hour energy while I make a cup of coffee. Everything has, so I've not finished my first cup of coffee. I'm still drinking it, but everything has not synced all the way between the 5-hour and the coffee. So if I'm a little ADHD this morning and a little all over the place, please be patient with me. It usually takes about 30 minutes after I have everything, for everything to kick in and work well together and my brain to calm down. So, so just be patient. All right. Now, this is what we're expecting today. So this court hearing was scheduled back in August. Okay. And the purpose for this hearing being scheduled was that Sarah Boone at the time was pro se, and she was going to be afforded the opportunity to review the state's physical evidence against her. Okay. Well, when this hearing was scheduled, when there was talk of Sarah viewing her the physical evidence that the state has, she made an oral motion. She did not want the media to be present. Okay. She felt like she deserved privacy. So even though she didn't realize that she'd made an oral motion, because first she asked the question, will the media be present? And then when Judge Kraynick answered her, she responded with, I would object to the media being present. Okay, so then another hearing was scheduled. And during that hearing, a representative for the media, an attorney for the media, came forward. It was for a specific media outlet. And right now, the outlet name escapes me, but it's not really germane to the conversation. Okay, so anyway, bottom line is that the attorney for the media spoke, and essentially the way that the rules go in Florida are a little bit different than other places. All right. In Florida, once the defendant receives their discovery, parts of that discovery then become available to the public. Okay. And if you're following Florida versus Stephen Stearns for the murder of Madeline Soto, you'll have noticed that there are lots of documents, interviews, stuff like that, pictures that are now available, because that's the way that Florida does things. So the judge said, look, the media representative is correct. You are not entitled to privacy. It doesn't have to be private. And the state also said, by the way, Sarah, if you had an attorney, what would happen is the attorney would come down to the sheriff's office where the evidence is being stored, and it wouldn't be private for them either, because they would come and view it. The state would be present along with, personnel from the sheriff's office, because it's, evidence. So there's a custodian of evidence who has to log everything that's removed, everything that's viewed, all of the things. So it's not really private. Is it done in open court? Typically, obviously not, but there it is. So then what was supposed to happen after that is, because at that very same hearing, okay, the judge said that, hey, by the way, your motion is overruled. It's not happening. I'm denying your motion. Not overruled. It's denied. So the state stood up and said, okay, Judge, we spoke.
Qualify for representation by the public defender's office in this matter. Can I get appearances, please?
Yes, Judge. Samantha Smith, and at this time, will enter pleading not guilty, waive reading the charges, and reserve the right to filing.
Okay. All right, sir, I'm going to give you 2 dates. You don't need to memorize these. You'll be given paperwork momentarily. The first date is the date of your pretrial conference. That's where we're going to discuss whether or not your case is ready to proceed to trial. That will take place on November 22nd at 1:30 in the afternoon. And if your case is ready to proceed to trial, it may be tried during the 2-week trial period beginning December 9th at 9 a.m. Before you leave here today, make sure you give all your contact communication information to your attorney to your right, and I wish you the best of luck, sir.
All right, I'm just going to turn it down a little bit because obviously the judge is hearing other cases. All right, so after the judge denied that motion, okay, the state stood up and they said, hey, we've already worked something out with Sarah. We're going to do it at the Orange County Jail. We're going to bring the evidence in. She's going to have the ability to look at it. And then we will, and the judge said, that's fine. But I'm going to keep this hearing on the docket. Maybe we can use it for something else, blah, blah, blah. But what he required was that, and the state agreed that they would be the ones that filed this. He needed notice. He needed to know what time this took place, how long it took, those types of things. The state and Sarah both agreed. However, that had to have been filed prior to today's hearing, okay? And it didn't happen. And we were talking last week when we saw that motion for dismissal, which was not filed by Sarah or anybody that Sarah speaks to. I went through the call logs that I have, that my friend B. Crumbs shared with me, and I could not find that specific name on the return envelope, or on the envelope in the return address. I could not find them listed, nor could I find, when I looked through like the phone numbers, an area code from California or out of state. The majority of Sarah Boone's phone calls are with a Florida area code. Okay, so I did that. So I was thinking, my gosh, they're running out of time to file this, because the reason it had to be filed is that Sarah was told by the judge, hey, after you view the evidence, the physical evidence, you have 2 weeks from that date to then file any of your objections. And then I will hear them to any of the evidence, right? What you don't want in, what you think shouldn't be let in, and why. Okay, 2 weeks from the date of the viewing of the evidence. All right. So in the interim of that, on August 30th, very, very late. Because when I looked at the timestamp, I want to tell you guys that it was barely August 30th. It was at like midnight that this was filed, or a little after. This attorney, Mr. Owens, filed a motion for continuance. Okay. Now, I've been watching around the law tubes, and it seems that I may have misinterpreted this motion for continuance, because they're saying that the motion for continuance is not based on the fact that Sarah retained a lawyer, but is based on the need for time to get expert witnesses to prepare for her defense. And so that's what is going on. I might be incorrect in that. Let's scooch forward just a little bit and see what's going on. Okay, so now we're live. All right, nothing. So, hey, Lathaby, good to see you. Hey, hippie chick. Hey, Tiffany. So I'm not an attorney, and I can only, to me, it sounded like something else. It sounded like he was saying, hey, I need more time to prepare for her case. She just retained me. That's what it sounded like to me, but the law tube says no. So I defer to their, hey, mean Ghoul Woofy. Oh, so I defer to their judgment, because they're, they're lawyers. I'm not. Okay. So there's that. I don't know what the judge is going to do, quite honestly. I mean, I think that it's going to depend greatly on the arguments, and it's going to depend on what the state has to say and all of the things. There is Sarah Boone. Wow, could they have sat her in a worse seat? Boone. Oh, I have to say, this is, hold on a minute. Let me see. Let me go over here. I think that I can fix it. I learned how to Zoom, you guys. Okay. Even though they're already zooming in on her. This is a face. This is a look we have not seen before on Boone.
Judge, I'm James Owens, and I'm representing Sarah Boone.
Sir, good morning, pleasure. Ms. Boone, good morning. Could you please state your, raise your right hand now, clerk's going to go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court. On August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in the court file. Mr. Cashore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigation?
Yo, those are nice. Hold on one second.
Candace, what's up? I think my daughter's going pro at basketball.
I'll take those.
Wait, you're a
Hang on, you guys. I might have to, hold on. Oh my gosh, I'm logged in on the wrong account. Hold on a minute. Let me switch. Hang on, just give me a second. Let me switch accounts.
And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times, haven't been able to find out what went on. I have talked to Ms. Cashman. The last.
We're going to rewind.
The costs and
All right, this is where we were.
With Mr. Boone at the Orange County Jail.
okay, all right. Ms.
I'll
Boone,
fix it, you
confirm
guys.
that
Don't you
that
worry.
Viewing took place.
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense that was filed on the 14th. The next day, August 15th, JSCS filed a response to the motions for payment of costs and appointment of neuropsychiatrist. Paragraph 10 of the JSC's response reflects that JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times, haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for battered spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I filed these, Judge, yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I put them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to the hearing.
Thank you. The only thing I saw in the court file, counsel, when I was prepping last night was the motion for statement of particulars. It's on September 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have a motion for statement of particulars filed 8/10 yesterday, but I do not have the motion for additional discovery filed 8/34.
I don't know why, the court was not able to post that, because they were filed one right after the other.
One's in the court file, the other three aren't. They're all filed yesterday, 19.
Certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JCS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They're not here. Your motions for these various experts report they were sent to all persons on service list through the e-portal. But I don't know how I can address these this morning without having JCS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I have, I filed my notice of appearance on Friday,
Yes, sir.
and I've spoken with Dr. Berklin 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Berklin. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and providing them to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB and we can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
If he wants to come back to my office, we can do it this morning / this afternoon.
You sure?
Office in the building?
Yes, it's in the courthouse.
Right there. Come out front door, make a left.
Okay. I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., the state will give you the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars formally and in writing, given the lack of time we've had to prepare to make a quick formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for statement of particulars and the motion for additional discovery?
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and the motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th. And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense, the court's going to deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, State, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Barrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist, make a request. You know, I want to make sure that there's not an issue about my client Sarah Boone not manufacturing the defense. And there's a second doctor, Dr. Michael Brandon. I don't spell that right for me, sir. Dr. Michael Brandon. I don't know.
B-R-A-N-N-E-N?
He spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband, shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brandon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brandon said victims of repeat violence may fear death in situations others would not.
And
I've tried to reach out to Mr. Brandon this weekend unsuccessfully. And my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. I will be, that's the only other witness I'm going to need an appointment for a forensic psychologist. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Burton. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making that she's a battered woman, we need evidence to corroborate that. So there's a lot of history between her and Mr. Torres involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these 2, as well as we're trying to get together the 911 calls that Sarah made and others made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved in their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other. Of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these witnesses.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I Can't imagine JACS may change their position with regard to those costs. They've already said yes, but file it. We'll try to tee it up for hearing as well to see if they have any position, or it could just be, the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right. That takes us now then to your motion for continuance file that was filed on August 30th. Court's had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Owens.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it. And it is critical to my theory, our theory of defense, battered spouse syndrome. And as you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a battered spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day, yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. I may have been.
Not me.
Okay.
My predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim. And I would respectfully ask, I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles, sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take a deposition. I think they may have the right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Cordelia has done a lot of work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We've tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. Based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense, because I don't believe my experts would be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Time Warner, who's on the state's witness list in this case, in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would oppose any continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice of intent to rely on the battered spouse on Monday. We can't wait a week that the time has expired if the judge doesn't continue it today. He wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said that 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, we're going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can file that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brand needs more time.
All right, thank you. State anything else?
No.
All right, thank you very much. All right, Mr. Owens, it seems like you've already started to dive into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you've met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, have such extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed, and that by your own representation you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020 under Mr. Padilla's representation of Ms. Boone. At no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz, Dr. Drury specializes in battered wife or battered spouse syndrome. Once by Dr. Bankwitz Mr. Bankwitz, on July 17, 2023 again, by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barber v. State, 221 Southern 3rd 562 at 569, there's a two-part test determining the need of experts. We're not going to be addressing that today as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here to have the opportunity to review those. In Roberts versus State, 75 Southern 3rd, 1277, at pinpoint 1281, by the Florida 4th DCA in 2011, citing to Lawson v. State, 884 Southern 2nd, 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change of counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankwitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and the findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida. From 2009 to 2012, you've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. And considering all the factors as set forth in terms of the state, 311 Southern 3rd, 185, and pinpoint 189, Florida 2nd DC of 2020, your motion for continuance is denied. Matter, this trial is still set for October 7th. We will have pre-trial the 6th to 27th. Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m.
OMG.
Judge, a couple of things. Number one, I have a full practice. I've got Dr. Day this afternoon in Santa Rosa County for Circuit Judge Scott Duncan. I've got 12 clients that are pending. I've got other people covering it, but I do have a full document. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
No, Your Honor.
The only request I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion and provide a form order, I'll sign it and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings when we can appear virtually. JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So
Hang on, Harlot. We're going to talk about it, babe.
Judge, in that pretrial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence
No,
from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to intend to introduce at trial. That has not happened. I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lang on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted. I don't know if they're the originals, but I'm going to need to look at that. And I went to the jail yesterday. I had let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to look, for me to look through the digital evidence as to what you're, I assume it's being redacted. I know some of the audio in terms of clients, comments my client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State?
tell them no, Cacciatore.
I'm not certain, is he asking for a continuance again? What is the extra time that he's seeking?
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd.
This already happened,
The
bruh.
state shall provide the defendant USB drive with station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order. I'm saying I haven't had a chance to view it either. Can we reset that deadline?
What?
Give me a moment. On August 9th, Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lang was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations by and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state's digital evidence, tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall file a court notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail according to the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m., a hearing will be held, courtroom 12A, regarding defendant's review of USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay, state?
No.
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to admit into evidence and tender any objections?
I've got to go by, but jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue, maybe a week prior to trial. Whatever that is, a week prior to that Monday, October the 7th, the week prior.
State?
I'm going to be amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Attorney Jones?
Give me 1 minute.
Sure. State, anything else?
Not this time, Your Honor.
Madam Clerk, going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties have no business before the court. You'll have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
Wow. Wowie, wow. All right, let's talk about this. Yes, it's over. All right. Now, I learned some things in this hearing about this client, about this attorney that I didn't know before because I didn't, frankly, Google this attorney. Mainly because I didn't want any preconceived notions about him. And therefore, can you hear me now, Shelly Beans? I was muted for a sec because I needed to make a motion for continuance. Can you guys hear me now? I hope so. Okay. I didn't want any preconceived notions. I wanted to be able to hear him and see how he presents his arguments without knowing anything about him. So I didn't Google him. And I didn't realize that he was coming from Pensacola. So it is a bit of a drive and or a quick flight, okay, to get from Pensacola, which is up in the northwest panhandle of the Floridas, to Orange County, which is in the middle of Florida. It's Central Florida. It's the Orlando area, Disneyland, Disney World, and Universal. Okay, those are the major landmarks and draws to. I wish it was Pepsi Cola, Mel, whatever. What I say? Pensacola. Okay. So that being said, I have this argument to make in rebuttal to the argument made by Mr. Owens. Sir, you know where you live. You know where your practice is located. You know where Sarah and this trial is being held. Okay? I'm not great at geography. However, I know where I live, and I know how long, if I were to decide that I wanted to represent Sarah Boone, I know that it's about an hour and a half, maybe 2-hour drive from where I am to where Sarah is. And that is a straight drive, not taking into account traffic. It's probably closer to maybe 2.5 if there's traffic, just to be on the safe side. Because I'm of the opinion, if you're on time, you're late. I like to get places a little early. Now, that being said, you knew that when you took on this case. You knew that you were going to have to be back and forth at a great distance, and you had to have certainly considered the fact that the judge may not grant your motion for continuance. And I think that you made good arguments in that, these expert witnesses are going to need time. However, this is where I personally believe the argument fell apart. Okay. You are intending to use expert witnesses that have already evaluated Miss Boone. And I don't think that there is anything that has changed substantially in her situation since they first interviewed Sarah Boone. And I think that's where the judge felt like your argument fell apart. Now, to the issue of who's paying for this. All right. I don't know who is the judge indicated he's completely pro bono, which means that he will not be filing with the JAC, who is in charge of handing out the funds for a pro se or an indigent defendant. Okay, so his fees, he's not going to try and recoup those expenses. However, because she is indigent, he is entitled to get the experts paid for. Now, to that end, the JAC from the beginning of this case, starting back in 2020, when Mauricio Padilla represented Sarah. Initially, she had court-appointed attorneys. They weren't on the case for that long before Mr. Padilla filed a motion before the court saying that he wanted to represent her. Okay, and initially he was a private paid-for attorney. However, that changed, and the JAC said, okay, she's indigent. She's been declared indigent. We're going to reimburse you. Okay, so that's how that happened. Okay. Now, I have to reiterate that I understand that there are people in the chat that are going to watch this now and that are going to watch this later, or watching now and watch this later, that are going to disagree and think that he should be allowed to have a continuance. I think personally that I actually thought that it wouldn't be denied. I didn't think that it would be granted in the way Mr. Owens wanted, which is to be ready for trial by the end of the year. I will say this. When I read his motion for continuance that he filed, I never, and I've seen like Law and Crime, Court TV, other art, places say that he's requesting to extend it by 3 weeks. When I read that motion, the way I interpreted it was he was stating a fact, not asking a question, meaning he was stating that they're roughly 3 weeks out from the trial. So, I didn't take that as he was requesting 3 additional weeks, which he wasn't. He's requesting like 3 additional months, because October 7th. So he said by the end of the year or the beginning of next year, which would be, we're in September now. So we have October, November, December would be 3 months. Beginning of January would be 4. So he's really asking for either, 3 or 4 month extension to get everything lined up. But the problem is that he is requesting, he wants to be able to figure out whether he feels Sarah Boone qualifies for the battered spouse syndrome defense. Okay. And I noted that he cited this specific case. I am somewhat familiar with that case, but I need to refresh my memory, and I'm not going to do that live because it's rude. I feel like if I have to, I need to read it, and then I need to be able to understand what I'm reading. So we definitely will be coming back tonight, and we're going to discuss this this battered wife syndrome defense in more detail. Once I've had an opportunity to understand what's going on, I want to be able to present it intelligently and cohesively. And when I am doing it on the fly like that, the ADD kicks in, or ADHD, and it's a bad news bears situation for me and for y'all. And I don't want to drag it out for you guys, because I know we all want to talk about this. So I want to have an opportunity also to look into these expert witnesses that he cited. But the bottom line is this. He cited a specific expert that has already worked on this case, that has already evaluated Sarah, okay, that's met with Sarah several times. And so this is a good question. Let me answer Sarah. So Harlotte Oscara says, are they pretty much saying she can't have any experts now? I don't see how 34 days is going to be enough for any expert to meet with her and be ready for trial. Well, no, that's not what they're saying. The expert that he requested is a psychologist by the name of Dr. Julie Harper. Okay. He also asked for another expert witness whose name is Dr. Michael Brannon. Now, Dr. Julie Harper has already evaluated Sarah Boone. She was an expert witness that was retained by Sarah Boone's first attorney, Mauricio Padilla, back in 2020. So she has had expert witnesses. And he wants to use this same witness. And so the judge is saying to him, she's already evaluated Sarah. She's already met with Sarah. As far as this battered spouse defense goes, there's nothing that in Sarah Boone's circumstances that have changed since she was first interviewed. So the bulk of the work towards that would have been done. Can she still go and meet with Sarah and maybe polish up her findings and reports and all that? Sure. But she's already evaluated her more than once. Okay. So that's why the judge is like, no dice, bruh. This has had enough time. So she does get expert witnesses. Now, the other expert witness that he wants is a crime scene reconstructionist named, it's either, I'm going to have to go back and listen and not look at the closed captions, because the closed captioned picked up Michael Berkeley, but it might be Birkland. So I need to go back and listen. They want a crime scene reconstructionist. I don't know what good that will do. It's not my defense. So I don't, potentially, I don't know. I don't know what they're going to do. But I thought that the judge would potentially extend the trial out a month. So meet him not quite halfway. So, but he didn't. He said, no, no, no. Also, he's met with Sarah Boone multiple times. And, I would think, based on what appeared, he has significant experience in representing people. He's been an attorney for quite some time now, criminal defense attorney. He also worked with the public defender's office at one point. So it would be, I'm not going to give him credit on a learning curve for how things work at the Orange County Jail. He met with her 4 times. So split the difference. By the second time that he met with her, he should have picked up on how things are done there. And if he wasn't sure, he should have asked questions. I would never, ever leave it to emailing a jail with a request to bring in my laptop and phone. I would want to do it in person, like, for example, at the end of the last time they met, because I'd rather have a question answered immediately and get it resolved rather than wait for somebody to check their email. Things happen. It's email is not always the most, you can't depend on technology 100% of the time, that, just because things happen. So that's, how I feel about that. I would have supported a 30-day continuance. I think, we've waited, and the victim's family, George's family, has waited this long. I think 30 more days would be sufficient. Now, KPM says crime scene investigation because I think he went down the stairs, right? But that wouldn't be helpful to Sarah. In fact, I think it would actually make things worse. If he went down this, are you saying that he went down the stairs in the suitcase or went down the stairs outside of the suitcase, like prior to getting in the suitcase? See, I need clarity on that. And the bottom line is this: when he took this case, okay, the thing about this case is that you don't have to be an attorney to be able to view the case history. It's all online. Everything filed, all the docket entries, all of it. It's all right there on the Orange County Clerk's website. That's how yours truly gets it. I don't have any magic powers. I'm not special. I just go to the county clerk. It's, and so he should have. What the judges basically said is, like, bruh, you knew what you were getting into when you took this case, okay? The only real question that I have after this is, how is Sarah going to react? Are we going to see another letter? Because my suspicion is this. My suspicion is that when he met with Sarah yesterday for the last time, he said, I'm going to argue for a continuance, okay? I think he was upfront with her, as most attorneys have been. I think what he said to her is, look, I'm going to argue for this motion for continuance based on A, B, C, and D, okay? But at the end of the day, it's ultimately up to the judge. the judge is going to decide. And I don't know what the position the state will take. So that's a variable that I can't account for. And essentially, Sarah, we're going to go into tomorrow with a 50-50 shot. He's either going to say yes or he's going to say no, right? I guarantee you Sarah heard something different. I guarantee you she heard, so you're saying there's a chance. You promised me that this would go great. We were going to get a continuance and everything was going to be fine and dandy. I just have this very, very strong feeling that that's what she heard. Because as you know, from watching her in court, while we're hearing what the judge is saying, we can, and then Sarah responds, it's like she is not attending or listening to the same thing we're all listening to. Okay. So she interprets things very, very differently than what is actually being said. What really remains to be seen, and I think this is why the judge did this, in my opinion, I think that it took so long to arrive at his ruling because I said it in the chat, I think he's going to deny it, and he wants to make a very, very clear record. Because I think that this has gone on long enough. And also, I think he's taking into consideration, we have been here with attorneys 4 times before, 5 times. I don't know. We're on, I think, attorney 9. Okay. This would be attorney 9. There were 3 attorneys that filed for withdrawal because of a conflict, not attributed to Sarah, something else. So all of the other attorneys, had a conflict with Sarah. And I think the judge is worried that should he extend the trial date out to even December, that's plenty of time for Sarah to have another conflict with this attorney and for the attorney to file a motion to withdraw, because Mr. Padilla was prepared to go to trial. And it was right before it was scheduled to actually go to trial, for the trial to start, that he filed for a motion to withdraw, which throws everything completely out of balance. And I think the judge was trying to avoid that, quite frankly. And I think that Sarah is going to give Mr. Owens an absolute rash of shit. I think that she's going to give him a tongue lashing. I think that she's mad. She's livid, because I really think she heard that this was going to go through no problem, that he promised her, because she just interprets things wrong. She just hears things incorrectly. Now, Yurts and Things asked way earlier, did the judge okay this new attorney? Yes. Here's the thing. Sarah has the right to counsel, okay? And if she retains an attorney by conventional means, like paying for one, okay, or an attorney decides to step up, which is what happened in this case, and do it pro bono, she is entitled to an attorney. What the judge took away was access to the public defender's office. She's not allowed. She forfeited her right to a public defender. So she can have an attorney. She just is not going to have one on the state's dime. That's what that's what the judge ruled. So that, yes, that's the deal. What else was I going to talk about? Let's see. Let me see what else is up here for. Okay, so this is a good point that Harlot Oscara says. Pinche Becky, this is her 9th lawyer. I just feel like the court shouldn't have let them revolve in and out for 4.5 years and then crack down and not allow the last one enough time to prepare. Okay. While I understand why you are feeling this way, and I think that you make a good argument, Judge Kraynick cannot do anything about the way that Judge Wooten ruled prior to this. And because, and this is something that we have to take into consideration, all right? The prior attorneys, before they got to Kraynick, so the attorneys I'm referencing that filed to withdraw that were heard before Wooten were Padilla, Bankowitz, and Hobson. Okay. Now, let me think what I was trying to say. I just got distracted. When they filed a motion to withdraw, they were heard before the court. And while all three of them said things that were very similar to each other, specifically about they couldn't ethically represent her. They were through for ethics, for reasons of ethics. However, and they could have, but chose not to. And they could have said in open court exactly what the deal was with that, exactly what they meant, exactly why they said what they said. But they were protecting Sarah because it was an open court. It would have been made part of the public record, and it could have potentially tainted her trial going forward. Okay. And I think that is the reason that this progressed in the way that it did. Okay. And to be fair, at the beginning of all of this, Mr. Padilla worked on the case for for 2 years before filing that. So you can't, it's not a revolving door of attorneys for 4 years. It's actually a revolving door of attorneys for 2, because Padilla worked for, sorry, I'm uncomfortable, you guys, my back is hurting and I keep fidgeting in my chair. I'm sorry. So if we really go back and take a look at the record, the court record with respect to the attorneys, it's not 4.5 years. It's 2, because Padilla worked on her case for 2 years prior to filing a motion to withdraw, which was granted by the court. Something significant had to have happened in order for an attorney who worked on this case for 2 years right before trial to say, I can't do this with her. I just can't. And there is, I think that something, like I said, something significant happened right then. I don't know if it is that when they discussed her defense, Mr. Padilla advised her, as most attorneys do. They do advise their clients not to take the stand. It is a dicey proposition. It's you can have all the trial prep in the world, and it won't really prepare you for a prosecutor coming at you with questions, because their job is to prove that you're guilty. It's always a dicey proposition for a defendant to take the stand. We've watched it many, many times, and it very rarely works out in favor of the defendant. They actually usually do more harm than good testifying. I don't know if that was part of it, if the argument arose, if the conflict arose from Sarah saying, well, you know what, I don't give a rat's fat kneecap what you say. I'm going to march myself up on that stand. I mean, if you look and read her letters, she certainly indicates that she wants to tell her story, not through her attorney. She wants to tell her story, which to me is indicative of a client who wants to take the stand. I don't know if that's how it started and it escalated from there. I don't know, because again, Mr. Padilla was protecting her and didn't cite specifics. The same thing happened with Mr. Bankowitz, and then Mr. Hobson. And then we got over to Judge Kraynick. And Judge Kraynick really dealt with Miss Cashman. And even Miss Cashman said, I can't work with her. I can't. And so Carolina says, Jen Lou, what I'd like to know, what digital evidence was Mr. James Owen asking for more time to review? He has met with his client 4 times before he signed on in her case. She has all of her discovery. Okay. So this is what had happened, and this is what I suspect they're talking about. Initially, when the order was first issued on June 28th, that Sarah forfeited her right to the public defender's office, what he did was he ordered the state and asked, and her PI agreed that they would turn over this evidence, this digital evidence, to her. And let me start over. They would turn over the discovery to her private investigator, and then he would scan all of the hard copies, the paper copies, and upload it to a USB drive, which he did. Then they had scheduled another hearing, and what the state did was turn over another USB drive that had the digital evidence on it. So the digital evidence that they're referring to, if I'm remembering correctly, and I will go back and watch these trials or watch these hearings so I can be prepared to discuss this much more intelligently tonight, is there are some surveillance videos that are on there. There are, I would imagine, there are Sarah's interrogation video, any other interviews that came through the Orange County Sheriff's Department, any other witnesses that were interviewed. I would think that the other digital evidence would be the body cam footage from the first responders, law enforcement, not the detectives on the scene. We've watched a lot of that body cam footage. I would think that that would be the bulk of the digital evidence. And so I think that's what they're talking about. So I think that the judge felt like you've had plenty of time. But what I'll do is I will extend your deadline and allow you to have more time to view the digital evidence. And what I'll do then is we will argue you need to have your motions for your arguments of objection on evidence ready for the pretrial conference, which is September 26th, 2024. So, I think that that's what he's talking about. But I will go back and I will listen again, and I will be prepared to show you why I think what I think. And I might have the same opinion or it might have changed, but I want to have time because I want to prepare to show you guys, why I think what I think, or, what this or that means, but I want to be able to show you why. I don't want you to just sit up here and say, well, this is this and that is that, like the seagull from The Little Mermaid, who thought a fork was a dingle hopper. Is that what he called it? Okay, Bo Peep, this is a good question. Who might be the state's witnesses? Any ideas? Okay, if I had to guess, we're going to have first responders the paramedics, because as we heard on the 911 call, while there were instructions being given on how to perform CPR, I'm not 100% convinced that Sarah did perform any CPR. Okay. So they're going to testify to that. They're going to testify to how they found George, because I'm given to understand that George was not completely out of the suitcase. He was half in and half out. So they will be the ones, they will be state witnesses. There will be obviously the cops that arrived on scene. Brian Boone, Sarah's ex-husband, will likely be a witness. I would imagine that the neighbors that heard the what they described as something coming tumbling down the stairs, that they will be called as witnesses. I'm sure that George's family will be, probably his mother, probably his brother, will be called as witnesses. I would think that the other people from the apartment complex that were interviewed by detectives, who were witnesses to previous arguments, fights, etc., between George and Sarah Boone, will be called as witnesses. The medical examiner will be called as a witness. Conversely, if the defense does put forth the battered spouse syndrome defense, there will be a witness to controvert that testimony. From the state, there will be a witness to controvert a battered spouse defense from the state. Okay, so there'll be that. Yeah. Oh my gosh, yes, I do remember that. Y'all remember Alex giving CPR to the pillow to give us an example for us? Yes, I do. I mean, yurts and things, absolutely. I'm not like, I like to support other creators, particularly creators who are actual attorneys or work currently or in the past in the legal field. My expertise, and that is in huge air quotes, comes from like watching things on watching trials, looking up documents in appellate courts. And my first case was the West Memphis 3 case that I ever looked into. And that was all back in, I think, 2001, I think is when I started researching that case. And at that point, they were going through the appeals process. And there were a lot of, motions filed and arguments and then orders and decisions, and they're all written in legalese, and I don't speak legalese because I'm not an attorney. So what I would do is I would have one window open of the decision and the arguments, right? And then I would be Googling what all of the terms meant, and I would continue to Google and Google and Google until I understood what I was reading. So absolutely, you can announce that. I'm never opposed to that. But so, yeah, I want to tonight, we're going to go over all of this. Let me look and see what the schedule for my friends going live looks like tonight. I know that Melissa, let me look. I know Melissa Jade has a live scheduled for tonight. Let's look and see what time that is scheduled. Let me look at her channel. Let's see. All right. She has a live scheduled at 7:30 for Tuesday trivia. I don't, I think all the things that we need to cover, and in order for them to cover them in depth, would be, I think 9 o'clock. I'm going to have to start at least at 9 o'clock. So that's what I'm going to do. I'll go live tonight at 9 o'clock, and we are going to go through what happened today more in depth. We're going to talk about we're going to talk about the potential battered spouse syndrome defense, what the criminal procedure is for that in Florida, because that's where we're having this trial. So that's where it matters. Oh no, Yurts, I get it, babe. No worries at all. Okay, this is a really, really good question. No, you're fine, Yurts and things. Don't you worry. I'm Eastern, Tony, because I'm over here in the Florida, some East Coast time. Bo Peep says, is James Owens locked into being Sarah's defense attorney now, or will he be allowed to withdraw? Wow, that is something that I wonder myself, quite frankly. And I don't think that I can answer this question accurately. I think that only really an attorney can answer this question. I don't think that there's ever a scenario where an attorney is forced to continue to represent a client. I think that the likelihood of him withdrawing is reduced significantly because, quite frankly, there isn't a lot of time between today and the trial starting. And so that cuts down on the, hopefully, on the level or on the amount of times, because he's not local to Central Florida. He is from Pensacola, which is in the Northwest Panhandle of Florida, right? Well, let me say the Panhandle is in the northwest part of Florida. He's from Pensacola, so that area. So I think that the fact that there wasn't a continuance granted, it definitely drastically cuts down the ability for a conflict of such significance that he would motion to withdraw. But I honestly don't think nothing is off the table at this point. Like, we're dealing with Sarah Boone. Okay. Okay. Let's get over to Court TV. Un momentito, por favor. We're going to get down to it. Hold on. Let me hold on a second. Okay, there we go. Let's get over to Court TV. Hold on a minute. That's not it. Oh, crap. I didn't mean to do that. Hold on. Well, if there's a press conference, let me find it. On Court TV. All right, let me search. Hang on just 1 second. We'll cover it. No need to leave. Where is Constance? Court TV has a press conference on with Sarah Boone's lawyer on Now Be Back. Okay. Let's see. Let me see if they're live. So let's see what's going on here. Hmm. Hmm. I don't see it live. I don't even see Court TV is live. Unless it's, all right, let's do it this way. Nope, not seeing it. That's fine. Let me just go here to just all the lives and see what I can see. No, I don't see it at all. Do any of the mods see what we're talking about? Okay. I don't see it on Court TV. So let me just, hold on. Let me look on my phone. Sometimes it's easier. Let me find it. Let me see if I can find it. We'll find it. If it's out there, I'll find it. Don't you worry. All right, hold on. Let me see. I mean, I see that there was a 37 minutes ago, but hold on. Let me look at this. I see Lori Shaver. That's not it. Okay. Because that's what the chapters are reflecting. There's my live. I don't actually even see. Let me see if there's. Let me see this. Let me look and see what you guys are saying. Yeah, can somebody send me a link, because I don't see. It's got to be on their website. Let me look on their website instead of YouTube. Oh my goodness. All right. It must be on their website. I think I found this. Let me see about if this is it. Hold on. Let's try it. Let's see if this is what everybody's talking about. All right, here we go.
Of course, is the defendant in the suitcase murder trial. She's supposed to be back in court next week for a motion hearing before her trial, which was set for about 30 days from just over 30 days from now. She's supposed to be going to trial.
This is old. This isn't it. Hang on a minute. Yeah, I don't. Okay, thank you, KPM, because I thought I was going bananas. It's on the site. YouTube is retained. Oh, Pinche, you can't, like, it won't, send it to my email, Pinche Becky. It's, yeah, if it's on your TV, I can't always see what's on the TV because all right, here's my email. Oh, obviously I typoed that. It should be Gmail, but blindjusticepodcast@gmail.com. Please email it to me at the end of the hearing. All right, hold on. Let's see. It's not on their website. Because I'm on their website and I clicked the hearing. Let me try YouTube and see if when they covered it, if it's on there. Let me look. Okay, Sarah Boone, let's see. All right, hold on. I'm looking for it, you guys. Give me just a second. All right, let me check my email. Hold on. Thank you, Pinche. I got it. Thank you, Pinche Becky. Let me see. Okay, you sent me just a link. Is it this first thing that pops up? Sarah Boone gets a new attorney? Is that what it is? All right, let me look on YouTube. 43 minutes ago, something they uploaded 43 minutes ago. All righty. Let's go look. y'all got a timestamp because I don't know if y'all are looking at this older gentleman, if that's who you guys are thinking is her attorney, because if that's what it is, hold on. That's a doctor. That's not her attorney. Um, hang on a minute. All right. I'm gonna show you guys what you guys sent me as the link. Okay. And I'm gonna just, this is what you're saying it is. So this is what I'm gonna go with. All right. Hang on a minute. Let me see. Sarah Boone gets new attorney because that's whatever that is what you sent, Pinche Becky. Oh, I see. Hold on a minute. I wonder if I can. Shit. All right, I see what it is. Hold on. I see what you guys are talking about. Okay. Hang on. Give me just a second. It's this. Right? Is that what this is? Hold on. Hold on. What the frack? Why can't I? Hold on. I'm sorry, you guys. I know I can see it on my phone. I can't see it. Hold on. All right, hold on a minute. I don't understand why it's different from my phone to this. Like, what is the deal? Hold on a minute. No, you guys, I appreciate it. I will figure this out. I see that this is, if it's on the website, it doesn't allow you to rewind. And so I can't see it from there. However, have no fear, because I would imagine that Court TV will end up uploading it to their let me see this, They will make a separate video, I think, and they will end up uploading it to their YouTube. And I will find that. Hold on. I wonder. Let me see something. Maybe I can just play the audio through my phone.
She, of course, is the defendant in the suitcase murder trial. She's supposed to
No,
be back in
that's
court
not
next
the one
week
I
for
want.
motion hearing.
All right. Well, I will figure out a way to get it. Don't you guys worry. Okay, so Tracy L is saying, well, anyway, her lawyer said that he's not pro bono. He was retained and Sarah owes him. How is she? This is what I don't, this makes no sense to me, as I know what you meant, Tracy, as an attorney. Okay, now I'm not an attorney. All right, but I understand math. All right. And if you have a client, if there's a person who comes to you and they have been declared indigent by the court, okay, multiple times, by the way, how are they going to pay you exactly? She's been in jail for the last 4.5 years. She's been in jail since the end of February of 2020, okay, awaiting trial. Where is the income coming from? How is it? How is she? How are you ever going to recoup your money? If he's all right. Let's try this again. I don't understand how he plans to get money from her, period. If you can, when you're saying 43 minutes ago, it's uploaded on their website, you're talking about literally www.courttv.com, not YouTube. Because I don't know what you guys are looking at, and I'm just trying to be clear so that maybe I can figure this out. But when I go to www.courttv.com, it doesn't show me how long ago anything was uploaded. What I'll do is this. How about this? I'll just search Sarah Boone and see what all comes up. Let's see what's going on Watch Live. Right now, what's on live is her 911 call. So maybe they'll replay it. Well, I'll share the screen because this is what's going on now live on Court TV. And maybe they will replay.
And thought it would be funny if he got inside of a suitcase for a game of hide and seek. The next day, deputies returned and arrested Boone and charged her with second-degree murder in Torres's death.
All right, well, let's look at Fox 35. Fox 35 website or Fox 35 YouTube?
Game gone awry unraveled
I'll
when
start with Fox
investigators say they
35
found
YouTube.
video on her cell phone showing Boone taunting and laughing at Torres while he was struggling to get out of the suitcase.
I can't breathe, babe.
Oh, that's what I feel like when you chewing on me.
Sarah, I
Ew.
can breathe, Sarah.
Yeah,
Let's see.
you should probably shut the.
When police questioned Boone the next morning, she seemed to have no memory of that happening.
I don't know if they suffocated her or if I had an aneurysm or a heart attack or what.
Boone
What's
told
going on
investigators
live?
she only realized her boyfriend was still in the suitcase when she woke up. Still, investigators say her actions add up to murder. Sarah Boone has pleaded
right.
not guilty and maintains her.
Oops, let me just put it on this.
This
Let's
has
see
been
if they play
dragging
it.
along too much. We're still going October 7th. If you want to represent her,
All right,
you
we'll
need to
watch
read
this.
in.
Give me
So
just
that
a second,
transition
okay? I
from
gotta let the
pro se
dog
to
out.
now being represented is happening in the Sarah Boone camp. Let's bring in for some analysis from Los Angeles, California deputy public defender for LA County, Philip DeBay. Good morning, Philip. What's your take on this judge's ruling to let's go? You have a month, get to work.
Oh, I thought it was brilliant. You know, in numerology, Ted, the number 9 represents completion of a cycle. So this judge should be heartened that this is number 9 because it sounds like this is the ticket. This is going to end the madness, you know? I'm actually happy for her in the end because she truly does need counsel, and I do think it'll move things along. And I have said this from the beginning, Ted, this is not a complicated case. The issue is going to be what was going through her mind when she put him in the suitcase, locked it up, and went to bed. Was it an intent to kill? Was it a depraved heart? Was it an implicit intent to kill? Or was it a straight up manslaughter? I think the jury could split the baby, kind of like what they did in the Ashley Benefield sort of retired ballerina case, where in Florida, if they can show that she committed an act, like putting him in a suitcase, without an intent to kill, but it caused the death, it's a manslaughter and it carries 15 years because luckily for Sarah, she didn't use a firearm or a knife. So her top would only be 15 years. And if Mr. Owens can achieve that for her, that is a huge win. And that would be my angle. Otherwise, I could see a jury easily coming back on a second degree, which tops it life behind bars.
The issue she has likely is that video that she took herself of watching him perish. Let's watch a couple minutes of Sarah Boone egging and basically taunting him while he's in the suitcase saying, Sarah, I can't breathe. Take a listen.
Yeah.
Sarah,
For everything you've done to me.
Sarah,
For everything you've done to me.
Sarah,
You.
Sarah,
You.
Sarah,
Stupid.
Sarah,
That's my name. Don't wear it up.
Sarah, I can't breathe, babe. Seriously,
Yeah, that's when you do when you choke me.
Sarah. 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 Sarah, I can't breathe, babe.
That's on you.
Sarah, I can't breathe. It's on you. Sarah. Real or ransom. Might want to get video for it extra. Because I got this. Sarah. Real or ransom. Sarah. Sarah, I can't breathe, babe.
All right, got it.
Oh, that's what I feel like when you cheat on me.
Only on Fox Local, 7 days a week, whenever you want us. We're taking local news to the next level.
Fox 35 News is always on Fox Local.
So why this case? Excuse me? Why this case? Sarah Boone needed a lawyer. I mean, I can't imagine our system. The case is an aberration. Okay, this just a gap in the system that hardly ever happens. You know, at the federal level, on the state level, everybody charged with a crime is entitled to counsel. Okay, everybody, never unless the client, unless the defendant waives their right and wants to represent themselves, which is rare and foolish. But I understand the judge's ruling. We respect the judge's ruling, but that left Sarah in a position where she's standing in a courtroom accused of murder without a lawyer. I can't think of any other time that you would need one than in that scenario. So once that decision was made by the court, Sarah put an ad out. Somehow it got on court TV. I watch a lot of YouTube, true crime. I saw it. I didn't immediately act on it. I waited 3 or 4 weeks thinking that one of the members of the defense bar here in Orlando would pick up the torch. 3 or 4 weeks went by. It did not happen. I had another case down here in Hillsborough County in Tampa that I had to come down for. So I wrote her a letter about a week before that. And she had a third party, a girl from Minnesota, that reached out to me, I think first just to.
All right. I just have to pause really quick for commentary, obviously, blah, blah, blah. Okay. But let me say this. Thank you guys. I appreciate it. We figured it out. It took a bit of doing, but we got it. And thank you, everybody. I appreciate it so very, very much. We all tried to find this. You guys were having to guide me, and it's super difficult to do it over text when you're limited on characters, but you came in clutch, and we get it. We got it. All right, here we go.
See if I was legitimate. They said to see if I would, I think catfishing is what they thought I was doing. Somehow, some fraud. I think once the third party realized that I was genuine, then Sarah called me. And we talked on the phone a couple of times, and I said, hey, I'm coming down that Wednesday for that court case in Tampa. Why don't I just come down Monday, which I did. I got done with court, I think, Monday at noon. I drove down 6 hours, spent the night, got up the next morning. I think that was on the 20th. And I spent about 4 hours with Sarah Boone at the Orange County Jail. During that period of time, I was in talks with the prosecutor, let him know what I was doing. He wanted me to file a notice of appearance. I wasn't ready to make that commitment yet. Didn't do that, but I got Sarah to sign a document essentially saying, you know, you can speak to the prosecutor on my behalf. There was attempts to try to resolve it. If we would have come to terms, I would have filed a notice of appearance. We would have set it for court, set it for hearing, and the case would have been resolved. So we did make attempts like everybody does in every case. Any prosecutor, any criminal defense lawyer, public defender, you have plea negotiations. That's just part of it. So there were attempts to settle it. I was kind of like a mediator. You know, I was kind of like a go-between, because once she became pro se, it's very difficult for the prosecutor to then communicate with the defendant. Actually, the rules say you got to do it on the record. And you can imagine not having somebody to negotiate for you, and she's trying to negotiate.
Thank you, babe. I got it. This is I'm on the Fox 35 Orlando website. You don't have to send a super chat, babe. Thank you. Is this not the thing? I mean, this is her attorney. He's speaking. Do I not have it right, babe? Is there something else? I'll look in a second. Okay. I'm so glad we stuck to it though, because, like we needed to see this and we needed to see it now. All right. And we did it. Thank you everybody for your help. I couldn't have done this without you guys. Okay. All right. So this is the thing. All right. So let's keep playing. All right. Here we go.
With the prosecutor trying to send her to prison for the rest of her life. So somebody had to do it. I was doing it. But after those, so I met with her that day. I went over to Tampa, handled my case. I think I was done at 2:30. I came back. Well, Billy Lane, the investigator that's assisting Sarah Boone, pro se, he had scheduled an appointment to meet with Sarah that night. So I went back over to the jail. They let me meet with them. So the three of us met. This was, I think, the 21st. Like it's set from 7 to 8:30. We met for about an hour and a half. And you know, at that point, we couldn't reach an agreement. And then I wasn't ready to represent her at that point. I immediately told the prosecutor that there was an impasse, there was no agreement, that I was not going to be representing her. I got in the car and drove back home, got home about 4. I had court the next morning at 8:30. I was done with the case. I did the best I could. I want to say 2 nights later, my wife and I were home and Sarah called and we talked again. Of course, I was still thinking about it, what to do. And, but I told Sarah I still was not committed to doing it. That was on like the 23rd. Well, then that third party called a day or 2 later, and really nice lady that I really respect. We developed a relationship, and she asked me if I would go one more time. So I flew back down. We met again a couple of times. I can't remember the dates now, 25th and the 26th. But both meetings went well. And you got to understand, Sarah's been through 8 lawyers, so there's some trust issues. And on both sides, you know, I'm concerned, is she going to try to fire me, or we're going to have problems the same way, as you can imagine. But, you know, I like her. She likes me. We communicate well. I think we're both on the same page. And, you know, I spoke to my family, my wife, my daughter Sarah about it. Sarah's thinking about law school, so I got their blessing. I have, you know, some colleagues that I practice law with, a law group there in Milton. And obviously it's going to take some staff to pull something like this off, especially knowing that the judge, I was in hopes he was going to continue it and give me 2 or 3 months. He did not. So we've got about 30 days. So I'm going to have some help from the staff, but we're trying to assemble a team right now. I've got a couple of friends that are lawyers that have indicated they're going to help me. And what are friends for?
Are you doing it pro bono?
I've been retained. I'm not doing it pro bono.
Who's paying for it?
Sarah owes me.
What?
Sarah owes me.
Can you speak a little more to your plan for defense of the battered spouse syndrome?
Well, you know, I'm not an expert, but I don't know if we're going to be able to do that because we're time crunched now. As you know, I think y'all understand the rule now. We've only got till the 9th, which was today, the 3rd. We've got 6 days. So I'm going to try to pay for Dr. Julie Harper to fly down here later this week. She's actually from my area. The 2 experts that I had asked for, well, there's a third one, but 2 of them are from my area. Dr. Harper's from Okaloosa County and Dr. Berkman's from Escambia County. But I've been in communication with Dr. Harper. I think I'm going to get her to fly down here later this week to meet with Sarah several times. Hopefully, at the end of those meetings, like I said, she's already met with her, but it was 2 years ago. She met with her 5 or 6 times. Hopefully, she's going to agree with me that she does suffer from battered spouse syndrome. And so then if she's able to give me that opinion by the end of this week, my intent is to file the notice with the court and the clerk of our intent to rely on that defense, and then we go from there. That's really all I can say. It's up to Dr. Harper, not me.
So you've got 6 days to do that. Now, barring a Matlock miracle and that doesn't occur, what is your other, I guess, plan of action?
Well, Sarah's been sitting in jail for a while. She's looking for her day in court, and we all want justice to be served. I'm a criminal defense lawyer. I've been doing it a long time. The state has the burden of proof. They have to prove their case. I know there's some strong evidence in the case, but there are some explanations. I'd rather not get into my other potential defenses, but we do have some defenses. They've got to convince the jury beyond a reasonable doubt. That's all I really want to say. Just like any other lawyer facing a trial on a criminal case, the state has the burden. We're going to test the state's evidence, and then we've got potentially a case to put on. But we'll see. We'll see what happens in this week. It'll be interesting to see if we can utilize, because I do believe she meets the criteria just from everything that I have viewed in terms of Mr. Torres's prior arrest. I did want to say something else, but I want to say something, but I'll wait for you. If you
We
got
gotta move downstairs.
Okay.
Or, I mean, we can just wrap it up.
We can just wrap it up.
I want to say this. The Torres brothers are violent.
Oh, God.
I'll say that again. The Torres brothers, George and Farrell Torres, are violent towards their women. Farrell Torres is George's brother. Are y'all aware of this?
Yes,
He was
we
arrested
are.
in May in Seminole County for killing his girlfriend, the mother of his children. He stabbed her to death. I've got the file right here.
We'll cover that tonight.
He called
Put it on the
911.
list.
Eventually, the 911 operator got around to, where is the weapon? Where is the knife? It was still in her head. I don't know. Sarah's told me about the family, the dysfunction. I seriously doubt that's going to be admissible in my trial. But there's two sides to every story. And Sarah's got a story to tell. I think she's been mistreated to some degree. It's difficult to represent yourself. I wish you could just imagine if you had a daughter that was in her situation where she's representing herself, or maybe a sister. Just for 10 minutes, just think about her situation. She's backed into a corner, and she's the type, like most of us are, they're going to come out swinging. That's what she's been doing. Some of it is probably appropriate. Some of it has been inappropriate, but it's all she knew to do was to fight. And she's been fighting. She didn't have to fight anymore. I'm going to do the fighting for her. So she feels good about it. I feel good about it. We want justice to be served. We feel like if we get a fair jury, that we got a good chance. That's all I'm saying.
Bruh.
Thank you.
All right. Terry, I can't. Okay, so let me do this. I can't do anything about their audio when I'm playing it from their website in the moment. This is what I will do. Okay. This is a lot. He said a lot in that quick statement. He made reference to George's brother and the accusations and pending charges against him. And I think that is because he said it, we're going to talk about it. And this is what I will do. I know now where this interview is. And so what I will do is I will screen record the interview and I will boost the audio so that tonight when we discuss this, we can hear it. You guys can all hear it very well. Pharrell Torres is his name. You know, I'll say this, and then I'm going to end the live. Anybody who would have taken on this case has a huge mountain to climb over, and that is the videos. And those videos were taken. So I need to go back and verify this, but Court TV has been reporting, and so is Law and Crime, that the videos that Sarah had on her phone were taken 3 hours apart. I don't think that's right. If I remember from the information filed, it was 3 minutes. But I will go back. It's on my list of things to double check. And we're going to talk about all of that. But regardless of whether it was 3 minutes or 3 hours, 3 minutes is more than enough time to hear his voice. You can hear it. He's pleading with her. He's saying that he can't breathe. He sounds muffled, as if he is actually having a difficult time breathing. That video is going to be shown to the jury. There's no way those videos don't come in. There's not an argument in the world that would cause the judge to not allow those videos in that I can think of, although I am not an attorney, but I strongly believe they're coming in. And a jury is going to see that. And while I understand that that is a huge burden, roadblock to hurdle to overcome, I don't think that what George's brother did has any bearing on this case, because the fact of the matter is, you can look in the court documents, you know, all of Sarah's criminal cases, as well as George's, are on the exact same website. Okay. And now that he's talked about it, well, we're going to have to pull that up. So if I were y'all, I would take a nap, because I'm going to go live tonight at 9 o'clock. And we are going to break all of this down. We're going to talk about what happened today in the hearing. We're going to talk about what happened, what this attorney said in this interview. We're going to go back and look at things. We're going to talk about her being interviewed by a previous expert witness who was approved by the JAC, whose attorney, her first attorney, Mr. Padilla, retained or used, excuse me, who's, you know, all the, we're going to mention it all, because 11 minutes. Thank you. 11 minutes apart. I knew it wasn't 3 hours. I cannot figure, I'm not going to listen to court. I mean, I'll listen to court TV, but I'm going to, you know, verify what they say, because I knew it wasn't 3 hours, but we are going to break all of this down and mention it all, because I think it's very important to understand what's going on here. But the bottom line for me right this minute, after hearing this is my initial impression. Okay. It's subject to change, but I don't think that bringing George's brother up was a good look for this case. I think that attacking the victim is a very, very dicey proposition. This is not a situation where she attacked him with some type of a weapon. She zipped him up in a suitcase. In that moment, he ceased to become a threat. He was contained, for lack of a better word. She could have left. She could have called 911. She could have done a great number of things. And what did she do? She took out her phone and she recorded not one, but 2 videos taunting him. Then she promptly took herself up the stairs, proceeded to get ready for bed, got into the bed, and accidentally on purpose fell asleep. That's not self-defense. That's not self-defense. And if I were this attorney, I would be very, very careful what I say in the media, because you may be new to this case, sir, but the rest of us have been following this case since 2020, okay? And we've done our homework, we've done our research, and we're going to hold you accountable for the words that come out of your mouth. And blaming George and saying that Sarah reacted in a way that is akin to self-defense is, in my opinion, in this moment at 11:27 a.m. on 9/3/2024, poppycock, and I don't appreciate it, okay? So I want to thank you guys all for being here. I appreciate it so much. I'm glad we finally got to see what he had to listen to, what he had to say. I think that we have a lot to talk about tonight. Like I said, 9 o'clock. You guys need to take a nap. I know I'm going to take a nap. But before you take a nap, I know that Alex Erickson intends to go live. She usually does an 8 o'clock in the morning coffee and true crime stream. She has some Madeline, some documents in the case against Stephen. I cannot say Stefan. I don't know why. It reminds me of Family Matters. You know, Stefan or Kel. Bruh, your name's Stephen. Anywho, she has some documents she wants to go over, and I think she's going to be doing that. Yes, Bo Peep, 9 p.m. Eastern Standard Time. Sorry, you guys. I need a drink. But so be on the lookout for that, because that's another case that I'm also following very closely along with Allie Erickson. She does a fantastic job breaking down the documents. And I think for me personally, the way that she handles this case and continues to, she will explain the documents. She talks about the documents, but she does it in a way that gives Maddie dignity. She just turned 13. And there's a lot of horrific and graphic details in some of these documents, but Allie does a great job breaking them down and still maintaining Madeline Soto's dignity. And I appreciate that. So I'm going to let you guys go. I'm going to play the outro for you all. I want to thank you again for being here. And we are going to break all of this down tonight, 9 p.m. Eastern. Thank you guys. Have a fantastic rest of your day. And I will see you later. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious intent or effort was towards it.
No malicious. Finish her.
Minutes later. all do a little math sometimes.
And you know this, man.